Hello everyone, welcome back. So I hope you all are preparing for your examinations. And as you see, we were discussing about law. This is a video in continuation of the law that we were discussing. So here I'm going to give you various differences of what various concepts that we have, and we usually tend to confuse between the concepts. And yes, we are going to discuss here the various concepts that we have, like assault, riot, and so other things that we are going to discuss. Okay. So, firstly, if we call when we are talking about law, basically there are various concepts that we usually have a problem with. Okay, so giving you clear definition or clear concept of it is the main target of this video. So that is why I have planned for differences. So let's start with it. What is the difference between three things: assault, affray, riot? Okay. See, firstly, we will do on the basis of place where it may be committed. Assault may be committed in any place. Affray must be committed in a public place, and riot may be committed in any place, public or private. Now coming to on the basis of number of persons required to commit the offense. Assault may be committed by one or more. Affray may be committed by two or more. Riot may be committed by five or more persons. Now discussing about the common effect. There may be or may not be any common object. There's no difference, or there is nothing of common object to affray. Whereas for riot, there must be a common object, and it must be one of the five mentioned in section 141 CPC. Next, coming to against what is the comments is the offense committed. For assault, it is an offense against the person or an individual. For affray, this must be the offense against the public peace. Let's talk about punishment. For assault, 3 months or rupees 500 or both according to section 352. For affray, 1 month or rupees 100 or both according to section 160. And for riot, 2 years or both according to section 147. So this was clearly the difference between assault, affray, and riot. I hope the three concepts are clear. If so, I'll move on to the next difference that I'm going to discuss is difference between kidnapping and abduction. What is the difference between kidnapping and abduction? See, kidnapping, the age of the person is victimized. Let's keeping this as our main point. Let's talk of this. Kidnapping from lawful guardianship is committed only in respect of a male minor under 16 or a female minor under 18 or a person of unsound mind. Whereas for abduction, the age of person victimized, abduction can be committed in respect of any person of any age. Now talking on the basis of means used. For kidnapping, the minor is simply taken away. The means used may be innocent. Whereas for abduction, it's a forceful offense, compulsion or deceitful means are used. Now talking of the consent of the victim. For kidnapping, the consent of the victim is entirely immaterial. Whereas for abduction, consent is freely and voluntarily given, condones abduction. Next, talking of intention of the offender. For kidnapping, the intention of the offender is wholly irrelevant. Whereas for abduction, the intention of the offender is an important factor. Next, talking of guardianship. For kidnapping, the person kidnapping must be removed out of a lawful guardian. A child without a guardian cannot be kidnapped. Whereas for abduction, Abduction has reference exclusively to the person abducted. Now, coming to whether a substantive offense, kidnapping, is a substantive offense, definitely. Abduction by itself is not punishable, but is made criminal only when it is committed with one or other intent specified in section 364 onwards. Now, coming to the basis of whether offense can be abated. Kidnapping from lawful guardianship cannot be abated. Abduction and kidnapping from India can be abated. So this was the clear difference between kidnapping and abduction that I have discussed. So I guess this is clear to you. Now I'd like to give you some more difference between theft, criminal misappropriation, and cheating. We often have a tendency to mix up all the three: theft, criminal misappropriation, or cheating. Coming to the intent of theft, to take dishonestly. Theft means to take dishonestly. For criminal misappropriation, the intent is to dishonestly misappropriate or convert to one's own use. To dishonestly misappropriate or convert to one's own use. And for cheating, fraudulently or dishonestly to induce the deceived person to deliver the property. Now coming to the property. The theft must, for property, if we talk of theft, it must be movable. For criminal misappropriation, the property must be movable or immovable. And for cheating, it does not matter. Next, coming to possession. For theft, property is taken out of another's possession. There is an invasion of right of possession. For misappropriation, offender is already in possession. Any property is induced to be of property. There is no invasion, divert, or any damage or harm done to the property. Okay. So I hope the difference between theft, criminal misappropriation, and cheating is clear. Now I'd like to give you some more differences regarding theft. Let's talk about theft, extortion, robbery, and dacoity. We'll do four together. Theft. Firstly, theft. Next, extortion. Next, robbery. Lastly, dacoity. Coming on the, we'll discuss on the basis of consent. For theft, offender takes without the owner's consent. For extortion, extortion is committed by the wrongful obtaining of consent. Robbery is an aggravated form of theft or extortion that the offender takes without consent. And dacoity, there is either no consent or consent is obtained wrongfully as in extortion. Next, coming to property. Theft can be committed in respect of movable property only. Extortion can be committed in respect of both kinds of properties, that's movable as well as immovable. And robbery or dacoity, in both the cases, it may be committed in respect of immovable property if it's a form of extortion, not otherwise. In theft, the element of force does not arise. If we talk of force, the element of force is not there at all. For extortion, the property is obtained by intentionally putting a person in fear of injury to that person or to another, thereby dishonestly inducing him to part with his property. And for robbery, force may not be used according as robbery is a form of theft or extortion. Now coming to the basis of number of culprits. The theft, extortion, or robbery can be committed by one person singly. But for dacoity, it should be more than one person, that's one or more. Coming to the element of fear. For theft, element of fear does not exist. For extortion, it does exist. For robbery, element of fear exists if robbery is a form of extortion, not if it's a form of theft. And for dacoity, element of fear does exist very much in dacoity. Now coming whether there is a delivery of the victim, whether there is a delivery by the victim. For theft, no. For extortion, it's yes, definitely. And for robbery and dacoity, no. If theft is committed while committing robbery or dacoity. Okay. So I hope the difference between theft, extortion, robbery, and dacoity is clear enough, right? So now I will move on. Before I move on, we usually have a doubt what extortion is. I'll give you another definition. Extortion is committed by the wrongful obtaining of consent. Okay. So that is what exactly extortion means. It might not be relevant to robbery, dacoity, or theft always. It's a wrongful consent that is obtained. Okay, so being very specific, extortion is committed by the wrongful obtaining of consent. Okay, so now I'd like to discuss two another most important things related to law, that's bailable and non-bailable offenses. The difference between them. So bailable offense, what's the meaning of bailable offense? Bailable offense means an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being enforced according to section 2A CRPC. And then what is non-bailable offenses? Non-bailable offense means any offense which is not bailable according to section 2E of CRPC. Bailable offenses are generally regarded as less grave and serious. In this, bail is a matter of right and it can be granted in the police station. Whereas for non-bailable offenses, these are graver or more serious. In this way, is a matter of discretion on of the court. If you talk about examples of bailable offenses, it can be voluntarily causing hurt. If you talk of non-bailable offenses, it can be murder, rape, theft, etc. Now I'd like to give you difference between cognizable offense and non-cognizable offense. What is a cognizable or what is non-cognizable offense? Cognizable offense means an offense for which a police officer may, in accordance with the first schedule or under any other law for the time being enforced, arrest without warrant, according to section 2C of CRPC. Non-cognizable offense, it means that an offense for which a police has no authority to arrest without warrant. That's under section 2.1 of CRPC. Cognizable offense is an offense where a police officer can take cognizance for arrest without any permission or order from a magistrate. If among two or more offenses one is cognizable, the whole case shall be deemed to be a cognizable case. Whereas for non-cognizable offenses, a police officer cannot take cognizance for arrest without any permission or order from a magistrate. If among two or more offenses, one is non-cognizable, the whole case shall not be deemed to be cognizable. Next, coming to whether these offenses are punishable or not. For cognizable, these are offenses for which punishment is imprisonment for 3 years or upwards according to the first schedule of the CRPC. Whereas for non-cognizable offenses, these offenses are punishable with imprisonment of not less than 5 years. Next, coming to the discussion of acquittal and discharge. What is the difference between acquittal and discharge? We often come across these terms in law. So, a person once acquitted cannot be rearrested. Whereas for discharge, if a person once discharged can be rearrested and committed for a further inquiry. An acquittal may also result from absence of complaint or withdrawal or a compounding of offense. Whereas for discharge, when a magistrate proceeds with less serious offense, it amounts to a discharge of graver charge, and the accused can be directed to be committed. An order of acquittal is a judicial decision after the complete inquiry and establishment of the innocence of the accused. An order of discharge simply means that there is no prima facie evidence against the accused to justify further inquiry in relation to the charge. Such order does not establish anything regarding the guilt of the accused. An acquittal bars a second trial on the same facts and for the same offense, or on the same facts for any other offense for which different charges from the one made against the accused might have been made under section 221, that's 221 1 of the code. Whereas for discharge, it does not bar the institution of fresh proceeding when new or better evidence becomes available against the accused. So this was the difference between acquittal and discharge. We often tend to confuse between both. So this was the clear definition and the difference that I have discussed. Next, I'll come to the discussion of compoundable and non-compoundable offenses. What is a compoundable offense and what is a non-compoundable offense? Compoundable offense, in compoundable offense, the law allows compromise, whereas for non-compoundable offenses, the law does not allow compromise. For compoundable offense, these are of private nature for which damage may be recovered in a civil action. For non-compoundable offenses, these are of public nature. Once an offense is compounded lawfully, it has an effect of acquittal of the accused. According to section 322, certain offenses need previous permission of the court before compounding the offenses. Whereas for non-compoundable offenses, these are tried according to law. The court has no power to permit the compounding of an offense outside the limits of section 320 of the code. So this was the clear definition between compoundable and non-compoundable offenses. So I hope this much was clear. So now we'll come to a very important discussion, that is difference between section 34 and section 149. This is very, very important, and yes, we do tend to make mistakes, and yes, we are going to go through this. So section 34, that's common intention. And section 149 defines common object. So section 34 talks about common intention and section 149 contemplates common object. Section 34 does not by itself create any specific offense, whereas section 149 does create offense in itself. Section 34, so the application of section 34, the meeting of minds, that's pre-arranged plan between the accused person is necessary. But for section 149, it is not so as in this case. For the application of section 149, it is sufficient that accused was a member of unlawful assembly when the offense was committed. Section 34 applies when two or more persons, including the accused, do a criminal act and must therefore be present when the act is done. Whereas section 149 applies only when there is an unlawful assembly of 5 or more persons. Section 34 has a wider application to cases of 2 or more persons, but the range is restricted to participation in a criminal act by all in furtherance of the common intention of all. Whereas section 149 is restricted in its application to 5 or more persons who from an unlawful assembly, but when section 149 is applicable, That is, when there is an unlawful assembly of 5 or more persons, Section 149 has a wider scope, unlike 34. Some activities, participation, especially in a crime involvement, physical violence is necessary under Section 34. Whereas for Section 149, it does not require so, and the liability arises by reason of mere membership of the unlawful assembly with common object, and there may be no active participation at all in the preparation and commission of the crime. Okay, so I hope the difference between common intention, that's Section 34, and common object, that's Section 149, is clear enough. Okay, so next I'll come to the last difference that I'm going to discuss in this video. That's the difference between rape and adultery. Okay, so when cases are filed, we often tend to confuse and we have to do research about this. So here is the clear-cut definition and the difference that I'm going to give you. Rape is an offense against the body, whereas adultery is an offense against marriage. Rape, for this offense, is committed without the consent of the woman, except under 16 years of age. For adultery, this offense is committed with the consent of a woman. This often lacks the consent of her husband. Rape, the aggravated party is a woman. For adultery, the aggravated party is the husband of the woman. Rape, a woman can be raped by her husband if she is below 15 years. A husband cannot commit this offense against his wife for adultery. For rape, this offense can be committed against married or unmarried women. For adultery, this offense can be committed with married women only. For rape, punishment is life imprisonment or 10 years or fine or both, but it can be reduced also in some cases. But for adultery, punishment, a period of 5 years or fine of both is. So I hope the difference between rape and adultery is clear enough. So in this video, I have given a lot many differences of adultery and rape, common intention and common object, compoundable offense, non-compoundable offense, acquittal, discharge, cognizable and non-cognizable offenses, bailable, non-bailable offenses, theft, extortion, robbery, dacoity, theft, criminal misappropriation, cheating, kidnapping, abduction, assault after riot. So all these definitions and differences have been clearly explained and the differences have been given. So do refer to them if you're preparing for law and if you want to have some knowledge about them. So this is a very useful video. Do follow the other videos for the rest of the law discussions that we're going to do. All the best and thank you.